COVID-19 pandemic. Our speaker this morning is Robert Bernstein. He's a partner in the Muchin firm in Chicago. Rob focuses his practice on the employer side, but he also does a whole lot, not just in the employment law side, but he also does a lot on the union and collective bargaining side, and he's spoken for us on those topics as well. So, Rob, I know you did your original TED-style talk for us, and you put together an exceptional outline that is included with that talk. So this morning, we want to take a little deeper dive into some of those topics. And I didn't know if you wanted to start a little bit. If not, I have a few questions to get us going.
Okay, I guess I could just start real briefly, Stephen. Thanks a lot. And, again, thanks for all you guys do during these tumultuous times, especially what's going on there in Houston. So much appreciated. But I'll just start by saying that, as I had mentioned in the TED Talks, I think that, there's this evolution here. The pandemic started in the February and March timeframe of 2020. And as we look at things a year later, during the pendency of that time, there's been, a good amount of litigation, as you could see from my slides. And, what we had also discussed in the TED Talk was that, I think we're going to, unfortunately, on top of everything else that we're dealing with, see more of these sort of claims as employers start bringing employees back to work, but maybe they don't bring back everyone. They pick and choose who they need to bring back. I think we're going to see more discrimination claims. I think we're going to see more retaliation type claims as employers become embroiled in situations where they have to make difficult decisions as to whether, employees telling them that they can't get the vaccine for different reasons, or they don't want to get the vaccine. As employers are faced with the prospect of employees who, for example, are in their 60s, just by way of example, and they say, we're more susceptible to coming back to an environment like that, or people who say that they have, disabilities or religious beliefs. I think that, one of the takeaways that I had from this is, employers more than ever, and then you add in, and I've spoken on this topic a lot recently, you add in, the change in the presidential administration. And what's the upshot there? Well, the upshot there is, in a lot of ways, we're going to be going back in the labor and employment sphere to, the Obama type era. We're going to drift away from, all these very, very pro hospitality employer and other business labor and employment laws and stances. And I think things under the Biden administration are going to be much more employee, much more union friendly, unfortunately, if you're on the employer side. And I mention that because you add that to the mix as it relates to the, increase or influx in these number of claims. And I think, I wish I was the bearer of better news. I really do. But I think when you combine all those things, it's going to be more important for hospitality employers than ever to make sure that they're vetting their safety protocols, make sure they're vetting their employee handbooks again, make sure that they're, vetting their wage and hour practices, because I don't think you're going to get as much of a pass as you did under the Trump administration. I expect that these government agencies are going to be renewed in their interest on these issues, as well as they're going to be equipped with greater resources. So with that as a broad overview, Stephen, I'm happy to, answer any questions, or if you guys want to, if it looks like there's a few more people on the, call now, if you want to direct me to certain topics you want to discuss more, by all means, please.
Thanks, Rob. And I agree with you. I think the shift is going to be, in some cases, significant. So we'll see. Rob, I did notice that in several of the cases that you cited, which I found really helpful and interesting. First of all, just generally speaking, it seemed to me as I went through those cases that in many instances, there just appeared to be a lack of empathy on the part of the employer to the employee's request. Did you kind of have that feeling as well?
I did, and then remind me to say one other thing as well to add to your comment, because I appreciate it, and I think you're sort of honing through the cases and finding a theme in them. I do think that's valid, and I found the same thing. And but what I would say about that is, Stephen, I'm not sure that's so unusual in terms of what sparks deep acrimonious litigation in the employment sector. I mean, how many times, even in a non-pandemic setting, but it's even more exacerbated in a pandemic setting because employees want their employer to be more empathetic, to use your word. But when I do these presentations, or when I'm when you read cases, when you're involved in litigation, the cases that seem to a lot of times to go deeper, and when I say deeper, I mean survive motions to dismiss, conceivably result in summary judgment briefing, or survive summary judgment and go to trial, are cases that a lot of times you scratch your head, not because you can't identify with what the employer did. A lot of times these employers need to make business decisions, and that's, again, I'm not naive about that, but and so maybe the word lack of empathy is too strong in some of these cases, but they're sparked by situations where employers made difficult business decisions that are conceivably susceptible in potentially emotional circumstances to spark bad blood, so to speak. So right. I do agree with you when I look at some of these cases. For example, like, let's say an employee over 60, or a pregnant employee, or someone with a disability says, employer, I can't return to work now. I don't want to return to work now because of the COVID environment. I'm more susceptible to certain medical conditions. My age makes me more susceptible to getting COVID. You're right. In some of these instances, employers made difficult decisions. I think, from a precedential standpoint, they were concerned sometimes. I think given the nature of the industry they were in, they were concerned sometimes. And they they took hardline stances, which resulted in claims. Right. But the other thing I'll mention, just from my experiences in dealing with a number of different type of clients, some clients, gosh darn, they're so on top of the safety protocols that need to be taken, like through the CDC and your state and local government guidelines. Like I'm in the city of Chicago. Well, we have city of Chicago things, we have Cook County things, other counties have type of safety measures that need to be taken. OSHA has things you need to pay attention to. The EEOC has things you need to pay attention to. Well, I found, a fairly decent disparity in how clients are reacting and responding to those different things, and how they're staying on top of it. And I think one of the messages is, through this is, God, it's going to be more important than ever for hospitality employers and other companies and entities in this Biden administration, where, just give you one example, where Biden has said that by March 15th, he wants, if there's going to be an emergency response guidance document from OSHA, that it needs to be put out by March 15th. Okay, and I bet we're going to see something. What else has Biden said? Well, he said he's going to increase the resources with OSHA by doubling the amount of investigators. And he said he's going to do the same thing with the Department of Labor. So I guess to my second point, I see some of these litigation situations also sparked by a differing level of compliance, if you want to call it that. Some are much more, and again, I say that too, because, these smaller employers sometimes, let's say they don't have a human resources department, or maybe they have one person and they're spread so thin. I mean, it's a Herculean task to stay on top of this for like you and me, Stephen. Imagine, someone who's got, 70 other things. So I do definitely think to bring it back full circle, that at times the empathy issue shines through, but I do also think, in my experiences from seeing these cases, it's precipitated by differing levels of compliance.
Yeah, I think that's a very fair point that you made. I want to, real quickly though, it does seem to me when I look at the cases that, several states passed laws, municipal ordinances were passed, but some didn't. And even still, it appears that cases were brought in the failure to provide safety category around COVID, right? Not spacing, not enforcing masks and things like that. That just seems to be more of a reasonable care type allegation, a breach of a duty of reasonable care. We typically don't see that very frequently in the employer-employee context.
Yeah.
Am I mistaken about that, or is this
No,
kind of
no, I think you're, I mean, I think we see it some, like, it's really a tort claim, right? I mean,
Right.
in essence. And so I think where we see, like, some tort type of claims are, like, I'll just give one example. Like in the, like we defend like tortious interference with employment contract type claims, like in the, in the non-compete type world more, and there might be other examples as well, but I think you're right. I mean, I think that those are claims that we're going to see more and more, including like wrongful death type claims.
Yeah.
Stephen, that you saw what I thought was interesting. I don't know what your reaction was, but like you saw those couple claims, one against McDonald's and one against Amazon, I think, for like the public nuisance doctrine.
Yes.
I mean, that's
yes.
a different type of claim where they're not seeking damages, but they're just trying to do public good, but to come back to your question, I think that's right. I think that in the employment world, we're more used to seeing statutorily based, type claims, more like Title VII based, state law anti-discrimination claims, ADA claims, you know what I mean? So I think it's fair. And one point I'll make just to close on this point is that, it underscores the need for employers to do what we were talking about a couple minutes ago, which is, if I'm an employer and I want to best insulate myself against whatever it is, a tort claim, a OSHA retaliation claim, you name it, I'm going to try as much as possible within the practical bounds of how I need to operate my business to be aligned with what the CDC says, what OSHA says, and what these other government regulatory bodies are saying I should be doing. Because if you've done that, I think you're going to look good before an agency or a court. Whereas conversely, if there's significant gaps between what these agencies are calling for and what you're doing as an employer, I think you're more susceptible and more susceptible to, muddier types of employment claims.
Yeah, I think that's a fair point. I also noticed, Rob, that several of the cases were dismissed relatively quickly.
Yeah.
Oftentimes for lack of jurisdiction, they didn't, they should have gone through an OSHA process instead of the court. So that's going to be interesting to track too. But I want to be mindful of our time, and I want to ask you a quick question about vaccinating. The general consensus from my research says that most employment lawyers are saying, yes, generally speaking, an employer may insist that an employee get vaccinated. And I was wondering if you fell into that camp. And of course, they offer exceptions, the ADA, religious, and then, needing to accommodate. But do you fall into that camp as well? And the other thing they say is, instead of insisting, perhaps it's better to provide encouragement or an incentive. So what are you thinking around those things?
I think, Steve, you summed up the way I feel, just about perfectly. I think that I agree. That's been my discussions with clients, but to maybe add a little more detail to what you said in terms of the way I think about things. A few things. Number one, I think that, well, not I think, I know there's been very little federal guidance on this issue right now. Okay, the only entity that is spoken about whether or not vaccines can be mandatory, in terms of employers making them mandatory, is the EEOC. The EEOC, if you go to www.eeoc.gov, they've come out with a guidance memo and Q&As, and they've said, to your point, that yes, from a federal standpoint, employers can make vaccines mandatory with a couple different caveats. Number one, that the vaccine cannot come, if they're making it mandatory, from an outside entity that they have a contract with. It's got to be arm's length. The people have to go to another entity. The second caveat, the second caveat is like an A and B, and you alluded to it, where they also say you can make it mandatory as an employer, but you have to engage in the interactive process or consider making reasonable accommodations for individuals with disabilities or who say, due to their religious beliefs, that they don't want the vaccine. If you do those things, they say it's okay from a federal level for employers to mandate. The other thing I should mention that they've come out with preliminarily is you may have heard, people on the phone may have heard about what's called voluntary wellness programs. Okay, and what I mean by that is the EEOC has taken the position, at least as of now, that COVID-19 vaccination programs are wellness programs. Okay, and in order to comport with the law, okay, the EEOC's position is that these wellness programs need to be voluntary. Okay, so what does that mean in this context? Well, what it means in this context is, to your point about how employers a lot of times are thinking that it's more prudent to take a wait and see approach and not mandate vaccines right now, but instead incentivize them or strongly encourage them, which I couldn't agree with more. I think that's the more prudent course of action now. If you are providing incentives, one thing that you need to be mindful of as an employer is you don't want to give too much or do too much by way of an incentive so as to risk making what could be deemed to be a voluntary wellness program involuntary. And that, I think that if you gave too big of rewards or gave too much of incentives,
oh, I see,
that could be an issue in the EEOC's eyes in terms of making these programs involuntary, which I think they would deem to be a problem. As you know, we're going to get more guidance on this, but if you look into this issue for those on the webinar, that's another consideration, as are other things like, let's say the employer gives gift cards, let's just say hypothetically, to incentivize the vaccine. Well, there's tax ramifications for the employees as to that, and you want to make sure that you're thinking these things through. In the only other thing I'll mention is, in a union environment where there's a collective bargaining agreement in place, you can't just do these things unilaterally. These things are likely going to be deemed to be mandatory, subjects of bargaining, where you're going to have to bargain with the union about it. So to bring it back to your question, the long answer to a short question is that I couldn't agree more with the way you said it, which is, federally, there hasn't been much, but the EEOC has said that you can mandate. Stay tuned over the next couple of weeks, because OSHA is going to probably come out with their stance, which I don't, let's see what they're going to say on that. But that doesn't mean that employers at this early juncture should mandate. I think that there's a more well-measured approach, which is maybe take a wait and see approach and strongly encourage it, maybe incentivize it, put your practices in writing. And I think that's the better approach now. And then the final thing I'll mention is I know that there's, to your conference, we have operators and companies in all different states. I know that from being at your conference, and state laws and local laws may be different as to whether an employer can mandate the vaccine. I know I've already seen different states, try to put stuff out saying that employers in a given state cannot mandate. So you really need to pay attention on the state level as well.
That's very helpful. Thank you. And great insight on the EEOC. Yeah, and listen, for those of you on and those of you that are listening later, if you didn't get a chance to listen to Rob's TED-style talk, I hope you will. He went through several areas of discrimination and the types of claims that are going on. And there's just really valuable information there. So I hope you'll take the time to do that if you haven't already. Rob, let's pause for just a moment and got a few people on and see if they have any questions. If not, I have a few more. Anybody have anything for Rob at this point?
It's terrifying, that's all.
Yeah, it is. David, it is terrifying. There's
Again,
no question about that. We'll have to wade through it. But David, something else before I go on with another question? I don't want to cut you off.
well, no, it's just you finally get comfortable with what you think 2 administrations ago that you've got it licked, and then the new administration comes in, and then we get a one-termer, and now we're switching again. So I look forward to you speaking on this for the next few years, Rob, because God only knows what's going to happen.
I think you're right. You know, one of the things I was saying in a webinar I was doing yesterday, and to your point, David, about it being terrified, how much time did we spend under the Obama administration is just one example, modifying employee handbooks for our both union and non-union clients, hours, because, one of the ways that the National Labor Relations Board got their, tentacles into the non-union sector was through administration of handbooks. Remember what a big deal that was, all the GC memos, but not, and then under Trump, it wasn't as big of a concern. Like, you could be more aggressive in your handbooks. And now I think you're going to have to look at handbooks again, because I think, for example, let's say you have your handbook that says you cannot be disrespectful to supervisors. Well, I think that's going to be a problem under Biden. That's going to be a problem. I mean, I think that is going to be deemed to chill Section 7 activity under the National Labor Relations Board. So that's just a simple, stark example. But yeah, David, you know what? I'm on your side. I share the pain, but I tell you what, it's gonna create a lot of to-dos for employers, especially as Biden, we evolve here. I mean, the National Labor Relations Board is going to be Democratic by the summer. They're going to have a Democratic majority. The Department of Labor already, he appointed Marty Walsh, who's got a long, rich union background. OSHA, he appointed a guy named Fredericks. He's got a 25-year United Steelworkers background. I mean, the list goes on. I mean, let's get ready.
Well, it just points out, I think, that it doesn't behoove any of us to have such divisiveness, because then every time there's a new administration, it's like a yo-yo or a snapback. And we've got to find a way to become more consistent and more stable. It just would help everybody if we did that. Listen, we have just a few minutes left. And Rob, I want to get to a couple of things. If Dave, if you're okay, you're good? Yeah. Rob, I noticed that there are a couple of cases around workers' comp. And so just to clarify for the attendees, is that workers' comp carriers and governments, et cetera, are starting to recognize, or have for a while now, recognized COVID claims as compensable. Did I get that right?
You have, but Steve, the only caveat I'll say, you have to look at the state you're in, because it's very state driven. And as we sit here right now, I haven't looked at all the 50 states,
Understood.
but it's you want to pay attention to the state. But for example, in Illinois and many other states, it can be compensable. Now you have to prove a nexus, that you contracted COVID through the workplace in some way. So it's not like a snap the finger automatic type of thing, but there's the potential that employers could be liable in this realm too. Yeah.
Kind of the same old course and scope of employment type.
Correct.
Okay. And so that's the foundation that I wanted to lay now. And I also noticed a wrongful death case or two. And typically, if I remember my workers' comp law back in law school, I won't tell you how long ago that was, but typically when there's a death involved and it becomes a gross negligence type of claim, then the worker or their family, of course, can opt out of the comp scheme and get actually into the courts and, litigation? That's what we're seeing, right? We're
I
seeing
think,
these- yeah.
yeah, I think, like, for example, I can't remember exactly, but I thought there was one against Walmart.
I think there was, yeah.
Yeah, and there's been more. And, Stephen, I think we're going to see more of those.
Yeah.
So, yeah, I think, to your point, wrongful death is a theory that, employees, family members, I think, are going to bring, especially, if they feel that, in certain situations, the companies may have deep pockets. I mean, I think, unfortunately, in our world, to, maybe try to assuage their pain some, or whatever it might be in the litigious world we live in, they may feel like they really don't have much to lose and everything to gain,
Yeah, no, I think that's a fair point. Well, it's going to be interesting. I think what I walked away with from the cases that you cited and looking at is that whether or not you have a law or a mandate in your state or your community, municipality to wear masks in the workplace or to, socially distance people, et cetera, we should be following the CDC guidelines as an employer, as well as, obviously, as you mentioned, the OSHA guidelines, et cetera, and the EEOC guidelines, because that's a reasonable care type approach. And I think we probably need to be ready to demonstrate that we took those steps. Even if you're not politically inclined to that, from a business perspective, it seems to me it makes sense just to avoid the litigation in the first place and to provide at least demonstrate diligence in terms of safety and security. It's like a duty of care.
I agree with you from the standard of care you mentioned. And
Yeah.
I also agree with you. Say you become embroiled in a, retaliation claim where you're defending that as a hotel or a hospitality employer. Well, you're going to look a lot better in the eyes of an agency or a court if you could say, look, this had nothing to do with retaliation. I was just telling the employee that I needed to follow X, Y, and Z, from your government agencies. If you can do that,
Yep.
I think, you're going to put yourself on a lot better stead to, either get rid of the claim or, to resolve it for something nominal, hopefully, and move on with your life.
Yeah, I think that's a really good point, to be able to demonstrate a basis for your decision, right?
Right.
That's really good guidance. Listen, we got to wrap up. And so I just want to say thank you very much. Putting together a fantastic outline. Thanks for your TED Talk. Thanks for this morning to kick us off. Always a pleasure to have you in our company. Your insight is always spot on, and today was no exception. Thanks a lot, Rob.
Thank you, Stephen, and to the group for being on. And Taylor, as I said, I really love the programs you guys have put on. I can't wait till we can all be together in person. And again, thanks for everything you do. Okay, we'll talk soon.
That sounds great. So everybody, we're going to take a 10-minute break now.